Is a handwritten will legal? Hi, I'm Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer, and today I would like to answer that question for you because it was recently brought to my attention by somebody who had that question. This is the story. A 50-year-old guy comes in, his dad recently passed away, and going through his dad's stuff, he found a last will and testament that was handwritten by his dad. And a number of his family members were saying, this will is illegal. So he wanted an answer. Let me give you an answer. The general rule is, in the state of Indiana, a handwritten will is legal as long as it meets all the requirements of a will. So what do we have to have? We have to have somebody who's of age. We have to have somebody who has the mental capacity to enter the will. It has to be in writing. It needs to be witnessed by two witnesses. And then if you want the will to be admitted into court, you have to have a self-proving affidavit signed by the testator, the dad, and the two witnesses saying he was of age, he had legal capacity to do this, nobody had a gun to his head, he knew what he was doing, he understood what was going on. So if that written will meets all those requirements, then it is a valid will. If there is no self-proving affidavit and the witnesses are still alive, you can also help prove the will and get it admitted into court if necessary through the testimony or affidavits of the witnesses to the will. So there you have it. Just because a will is handwritten does not make it illegal. As long as it meets the requirements of the state of Indiana, whether it's written or typed. If you have any questions, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.